So I'll start with our land acknowledgement. Today, we may be coming from very many diverse parts of Canada, lands that include both ceded and unceded territories, lands that are sacred to many different Indigenous peoples. Today, in the spirit of that reconciliation, I want to pay respects to the many Indigenous peoples past and present, the First Nations, Métis, and Inuit who have deep connections to this land and for whom this land is home. Just before Christmas, we had a data release of the ongoing opioid crisis in our province. Opioid use is not limited to any one group, but the intersection of drug use with key vulnerabilities means that the burden of harms is disproportionately borne by some populations within our communities. This data release reminds us that this crisis is disproportionately impacting the Indigenous community. These stats should be a call to real action. It is only through a commitment to true reconciliation and decolonization that we can begin to support our Indigenous partners and join with them to address the devastation from this crisis. Opioid poisonings are a complex issue. There will be no single solution to addressing these preventable deaths. The solutions need to be designed in partnership with our community, and tonight we will be sharing and hearing about one approach to addressing this public health emergency. I'm grateful to Caitlin Shane for agreeing to discuss decriminalization with our group tonight. We welcome her. First, I'd like to introduce Caitlin Shane. She's a staff lawyer at Pivot Legal Society, a human rights legal organization based in the downtown east side of Vancouver. As the head of Pivot's drug policy campaign, Caitlin advocates for the decriminalization of people who use drugs and the legal regulation of all controlled substances. Caitlin has appeared at the Supreme Court of Canada, the Federal Court of Canada, BC Supreme Court, and various standing committees of the Senate and House of Commons. Please join me tonight in welcoming Caitlin virtually to Edmonton. Hi, Caitlin.
Hi, everyone. Thanks so much for having me. So thanks for the introduction. Thanks so much for having me today. It's always a pleasure to join folks who are interested in talking about these very timely policies that are continuing to take center stage in our discussions with government and among people who use drugs. So as was mentioned, I'm a staff lawyer of drug policy at Pivot Legal Society, and a big portion of my work involves working directly with people who use drugs to challenge existing laws and policies and practices that disproportionately impact people who use drugs. So that includes drug criminalization and prohibition. So I'm joining you today from the stolen lands of the Musqueam, Squamish, and Tsleil-Waututh peoples in so-called Vancouver, BC. That's also where my office is located, and it's the home of many of the people that I work with and who are my clients and comrades. I'm grateful to Indigenous peoples for their relationship with the land and also for their leadership in developing a lot of the policy alternatives that we're going to be talking about today. Obviously, Canada's drug laws disproportionately impact Black, Indigenous, and peoples of color. And so part of my work and advocacy is deeply tied to the liberation struggles of Indigenous folks. So just adding on to the earlier territorial acknowledgement. As far as an overview goes, my hope is first to talk about drug prohibition generally. Drug prohibition gets carried out at various different levels of government, even though it's oftentimes federal laws that we're talking about. The provinces and the municipalities have a role to play too, both in the enforcement of drug prohibition and in the solutions to address the harms of prohibition. Then I'm going to talk about decriminalization and legal regulation, both as concepts that have been presented as alternatives to drug prohibition, and that are the advocacy of which is being led by people who use drugs. I want to make sure that we have an understanding of the difference between these concepts, the fact that it's not a one or the other, and that they work hand in hand together to serve different purposes. There's various different models of decriminalization and of legal regulation. I want to talk about those. And then also some of the points around efficacy of decriminalization and legal regulation. So both of these policies have strengths, they have weaknesses, neither is a panacea. And so that's all the more important why we understand why it's necessary to advocate for both if we're to address the harms of drug prohibition. So starting from the very top with federal drug prohibition, the main source of our drug prohibition in Canada comes from federal drug laws. The Controlled Drugs and Substances Act is a federal piece of legislation, And it basically relates to all drug-related activities and prohibits them, whether it's possession, trafficking, importing, exporting, production. All of these activities related to substances are governed by that federal piece of legislation. Interestingly, in 2016, the federal government announced that it would be taking a public health approach to substance use rather than a criminal justice approach. And it actually went so far as to move the portfolio of substance use from the Ministry of Public Safety to the Ministry of Health. Now, that's obviously a good step forward, but given that our federal laws continue to prohibit virtually every activity related to substances, we have arrived at a place where people who use drugs are getting very mixed messages about whether this is a criminal matter, and if it's not, why are people still getting arrested? Importantly, there are carve-outs where drug possession is not illegal. And the primary two contexts in which that takes place are prescriptions and federal exemptions. So as folks on this call are well aware, prescription is a form of legal regulation. It's a way through which people can possess otherwise illicit substances, provided that they have the proper prescription and it's for them. The other way that we see an exemption kind of playing out from the Controlled Drugs and Substances Act is under a provision, Section 56, that deals with exemptions. And this is a power that's given to the Federal Minister of Health, and she can basically exempt any person or group of people from any provision or multiple provisions of the Controlled Drugs and Substances Act. So that's how we have seen supervised consumption sites be established. These are places where the minister has granted an exemption from the offense of simple possession to clients and operators of those sites. And I'm going to talk a little bit later about ways in which this exemption power is being used creatively lately, to the end that provinces and municipalities are actually applying for these exemptions on geographic scales to exempt entire jurisdictions of people against the offense of simple possession, so that we effectively have de facto decriminalization in areas that have been granted exemptions. I do want to point out it's really no coincidence that the carve-outs to prohibition, namely prescriptions and federal exemptions, are largely medical in nature. Medicalization can of course have its benefits, but as people who use drugs are pointing out, it is increasingly being used as a tool to effectively continue to control people who use drugs and drug possession. It's not to say that there is not a place for prescriptions and a medical model should that be what people need, but drug use and drug possession is not always a medical issue. And the fact that we treat it exclusively as either criminal or medical comes with a lot of shortcomings, in my opinion. Moving on to provincial drug prohibition. So we've talked about how the criminal law is federal in nature. That's written in our constitution. Federal government has exclusive power over the criminal law, but the provinces have significant control over health, the health of people in the province and the delivery of healthcare. So that's why provincial laws and policies tend to be concerned with drugs in the medical context. The provinces control the dispensing and prescribing of substances. They implement guidelines for drug dispensation, so who can dispense drugs and where. They establish the oversight bodies, the colleges of physicians and pharmacists. They decide whether to fund or not certain programs for people who use drugs. And even though, as I mentioned, the province doesn't have control over the criminal law, their jurisdiction over health does give them some license to implement creative drug policy strategies, even under this overarching umbrella of the criminal law. And this is particularly the case as we continue to frame substance use as a public health issue. Then naturally, the level of government that maintains authority over public health has a significant role to play. And we saw that very clearly in BC. In 2016, a public health emergency was declared around the opioid crisis. And given the length of time and the onerous process that was involved in applying for supervised consumption sites, these life-saving sites, in the context of extremely high rates of death, the province harnessed its power over health And the Minister of Health at the provincial level issued an order to all of the health authorities saying that overdose prevention services must exist in every health authority in the province and must be set up where there is need. So that was really an example of a province demonstrating political will and acknowledging that regardless of what federal drug laws say, this is a health issue. And there are things that we can do using our health power to improve drug policy locally. Now, municipal drug prohibition is something that oftentimes gets overlooked. We tend to think of drug prohibition as being federal and at times provincial, but the municipal level of drug prohibition is really where people's experiences of the war on drugs are localized. Drug prohibition gets carried out by a network of local agents. Police are key to that network, but they're also aided by law enforcement officers, private security, community policing stations, and general community stigma. So for instance, you could have a police officer enforcing the Controlled Drugs and Substances Act, let's say simple possession when someone possesses drugs, but also many communities have bylaws that prohibit, for instance, the carrying of harm reduction supplies, including sterile injection equipment. So police don't enforce bylaws, bylaw officers enforce bylaws. So you can see how this sort of network of enforcement comes together to enforce what is quite a complex web of drug-related laws and policies. Now, prohibition at this point has been proven ineffective in reducing both the use and availability of illicit substances. And part of the problem is that prohibition seeks to respond to supply by banning it entirely. And in doing that, it ignores the demand side of the transaction and all the very real and legitimate ways and reasons why people use drugs. People have always used drugs. People always will use drugs. And when we have a blanket prohibition policy, we relinquish any control or regulation of those substances. We also ignore the reasons why people who use drugs and people wind up accessing drugs in unregulated spaces, i.e. the illicit drug market. So it's no secret or no surprise that under drug prohibition, we have a thriving illicit market. And because substances in that market are unregulated and are entirely profit motivated, what we've seen is more and more potent strains of substances saturating that market, fentanyl being one, for instance. So based on those findings, that drug prohibition isn't working, that it's caused this illicit market, which is in turn causing profound death rates, calls for alternatives have really increased lately. And one of those calls, and this is a call that people who use drugs have been making for decades, is decriminalization. Decriminalization refers to removing criminal sanctions for simple drug possession. And simple drug possession is possession of substances for your own use. It does not include possession of substances with the intention of sharing or trafficking. It does not include drug sales. It is simply possessing drugs that you intend to use for yourself. When people talk about drug decriminalization in North America, they're talking about removing criminal sanctions for simple drug possession. There are increasing calls to also decriminalize things like street-based trafficking, drug splitting and sharing, but generally decriminalization is just removing penalties for simple drug possession. There's two kind of modes of decriminalization. One is de jure, which is where you actually formally amend, repeal, change the law itself. So that would be the federal government coming in and amending the provision in the Controlled Drugs and Substances Act that deals with prohibition of simple possession. But then there's also something called de facto decriminalization, which refers to not formal changes in the law, but practical changes in the enforcement of the law. So this can be a quicker way to achieve decriminalization without having to go through the legislative process, which can obviously be very time consuming. So de facto decriminalization can be carried out by any level of government. It can take the form of guidelines. We've seen police departments adopt policies of non-enforcement. It can be through this exemption process that I'll talk about shortly. But it's suffice to know that there's kind of these two ways of achieving effective decriminalization. Decriminalization, governments have said a lot that decriminalization is not a silver bullet. And they are right. It is not a silver bullet. No one who has ever advocated for decriminalization has claimed it to be a panacea. Evidently, if we have a toxic drug supply, the fact of removing criminal sanctions for possessing that supply does not mean that overnight people will have access to a legally regulated supply. That's legal regulation, and we'll talk about that shortly. But decriminalization, the way that I frame it, is basic harm reduction. Under prohibition, drug use is driven underground. People constantly fear arrest, they fear detection, so that means they're using drugs alone. They're not talking to their families about it. They're not talking to their doctors about it. In the context of supervised consumption sites and overdose prevention sites, we have these spaces where people can legally possess drugs, but they have no legal avenue to get to that site. So a person walking to a decriminalized site, like a supervised consumption site with drug in hand, is still liable to arrest for simple possession, even though they're making their way to the space that they're being told to go to use drugs. Decriminalization seeks to reduce the harms of criminalization, to bring drug use out of the shadows, to ensure that people feel legally confident accessing supervised consumption sites and harm reduction sites, so that people feel comfortable talking to their families about their drug use, so that they can talk to their doctors about their drug use, which can in turn translate to more appropriate pain prescribing, and ultimately a decreased reliance on the illicit market. Criminalization is obviously a huge driver of stigma, and one of the key elements of decriminalization is reducing that stigma so that we can actually talk openly and frankly about drug use, which happens all the time, every day. But so long as it's shadowed, people are forced to engage in far riskier drug use behaviors or activities. And that's kind of the key benefit of decriminalization. As far as actual models of decriminalization go, these can really vary depending where a country or a province or a jurisdiction is at in terms of its perspective or philosophy around substance use. I find it helpful to categorize models of decriminalization as either partial or full. So ironically, the most well-known example of decriminalization is Portugal, the Portugal model. But in Portugal, they actually haven't fully decriminalized. They've only partially decriminalized. And the same is true in Oregon. And that's because in these jurisdictions, while it isn't a criminal offense to possess personal amounts of drugs, it is an administrative offense. So in both Portugal and Oregon, a person who is found to possess substances by police, so police are still patrolling for this activity, a person can face a fine or a health assessment. In all cases, they are typically required to attend something called a dissuasion commission, which is a panel with a doctor and a lawyer, and I believe a social worker, to talk about what the appropriate response is, which could include, financial penalties, license removal, etc. And what's really important to take away from that is that drug users in Portugal authored a really incredible report on how the Portugal model impacted them. And they said that administrative sanctions are still penalties, and that still gets targeted against the most marginalized drug users. It's people who are unhoused, people arguably most in need of decriminalization, who are being continuously targeted by administrative sanctions. If a person can't pay a fine, the imposition of a fine is a strong reason to continue to engage in drug use underground. So in this way, administrative penalties can risk mirroring criminal penalties, or at least have the same effect of continuing to drive drug use underground. So full decriminalization refers to the removal of all penalties, criminal or administrative or otherwise, for drug possession. And the Portuguese drug user group in their report said, decriminalization must mean just that, not partial decriminalization, not compulsory drug dissuasion committees, but full decriminalization of people who use drugs, a full removal of all criminalizing legislation and policy, as well as penalization and sanctioning related to people's personal use. And none of this is to say that we shouldn't be scaling up health services and supports. We should always be ensuring that people who use drugs have access to services and supports, as well as everyone else in society. The point, though, is that those services should not be liaised by police. They should not be gate-kept by officers who are continuing to monitor and interfere with people's substance use. So I'll take a minute just to talk about some progress that we've seen here in Vancouver and BC, and potentially in Toronto. We talked a little bit earlier about the exemption power of the Federal Minister of Health. Under Section 56, she can exempt any person or group of people from any provision under the Act. And that includes exempting all people in a geographic location from the simple possession offense. A couple of years ago, Pivot authored a report called Act Now, Decriminalizing Drugs in Vancouver, and we called on non-federal levels of government to apply to the federal government for an exemption to be used in this novel way, on a geographic scale rather than very contained, like supervised consumption site type scenario. Vancouver went ahead and submitted its application in May of 2021. They took the approach of adopting something called threshold quantities, which basically means that possession of a substance up to X amount becomes decriminalized. You cannot be penalized for possessing up to 2 grams of opioids, 3 grams of cocaine, 10 rocks of crack cocaine, and 1.5 grams of amphetamines. If you possess more than those threshold quantities, you can still be charged with simple possession or possession for the purposes of trafficking, whatever it is that the officer has identified you as doing. BC submitted its application for a BC-wide exemption, so that would apply to all adults in BC. And in both Vancouver and BC, it's adults only, youth are excluded from the exemption, just FYI. So BC submitted its application in November of 2021. And rather than set individual threshold quantities for individual substances, they went perhaps a simpler route of identifying a single cumulative threshold quantity of 4.5 grams. So an adult in BC, if this application is approved, can possess up to 4.5 grams of opioids, cocaine, crack, amphetamines, and MDMA. You can have bits and pieces of any or all of those substances up to a cap of 4.5 grams. Toronto is currently in the stage of drafting its application. Both Vancouver and BC, while they have submitted their applications, have not yet been approved. I understand at least that BC is in the iterative process right now, so it's a bit of a back and forth with Health Canada, kind of discussing and navigating the different qualities and features of the model. And it's also not clear what's going to happen in terms of whether Vancouver's and BC's applications can coexist. Will the federal government simply say, we're just going to use one model for all of BC, including Vancouver, or will they say, we have a BC model and Vancouver has its own separate policy? That remains to be seen. Under both exemption applications, trafficking continues to remain illegal in every context. And again, simple possession of above threshold amounts is illegal. Both BC and Vancouver rejected the use of administrative or other penalties, including fines or treatment. And that was because there was very strong direction from the health authorities and the Ministry of Mental Health and Addictions in BC that administrative sanctions cause harm, and that if we truly want to benefit from decriminalization, then we need to fully decriminalize and not penalize people administratively. The one sort of response that could be interpreted, I suppose, as penalizing is that police will hand out referral cards to services for people who use drugs, but there's no requirement that the person receiving the referral attend said referral. It's more meant to be an information sheet that says, you know, here are harm reduction sites, here is where you could go for eye-out, whatever it is. So we'll stay tuned to see kind of what happens there. I don't know how close we are to receiving an approval, if we receive an approval, but BC and Vancouver at least are well on their way to moving in that direction. Given that decriminalization doesn't address the toxic drug supply, right? That's kind of the main critique of decriminalization, is that if you simply remove the threat of arrest for possessing drugs, people are still going to be using toxic drugs from the illicit market. And so given that, there have been stronger and stronger calls for something called legal regulation. And legal regulation refers to the process of making something legal and then tempering or constraining it through imposing regulations. And we already regulate all sorts of things, whether it's buying alcohol and tobacco, driving a car, purchasing toothpaste. All of these are examples of regulation that happens every day in Canada. And in all of those instances, if we ask why do we regulate, it's to ensure, one, quality control. So in the context of legal regulation of substances, it would be to ensure quality over the currently toxic drug supply, a safer supply of substances. And two, to control who can access substances. An important thing to acknowledge is that legal regulation, despite what people think, is not a free market. It's not a free-for-all. Cannabis was legalized in Canada in 2018. That doesn't mean that you can use cannabis unlimitedly. So even though cannabis was removed from the Controlled Drugs and Substances Act, they introduced the cannabis, I believe it's the Cannabis Act. So that's a law that further tailors who can access cannabis and how, right? You can only have a certain number of plants. You can only get it from licensed dispensaries. If you use cannabis outside of the regulatory framework, you're still subject to the criminal law. Legal regulation really is the middle ground between prohibition and a free market. Because ironically, both prohibition and the free market are similar in terms of entirely lacking regulation and control, quality control, et cetera, and being entirely profit motivated. It's only by regulating drugs that we can actually address the toxicity of the supply by ensuring substances meet a quality standard and access to that supply. So just to rehash, the primary benefit of legal regulation is more control. Not only can we control the potency of illicit substances, we can also control every link of the drug supply chain. So controlling who manufactures a substance, who can sell it, who can buy it, who can dispense it, where and how it can be consumed. None of that is possible under prohibition. When people have access to prescription grade substances, and I'm not saying it has to be by prescription every time. I think we need to broaden our concept of how people can access substances, but prescription grade quality substances. The current illicit market, as I said earlier, it is booming under prohibition. And when we introduce legal pathways for people to access the substances they want and need, there's automatically less reliance on the illicit market. Again, under prohibition, we basically turn a blind eye to a market that we know is thriving. We turn a blind eye to people who we know need substances, and we basically allow them to rely on that incredibly toxic market. Regulation can change that. And it can also go ways to reduce the stigma that we talked about earlier, that really forces people to use drugs in isolation and not speak openly about substance use. So this is the last slide. I use it because I think it's helpful to visualize sort of what we're talking about when we say legal regulation. The chart shows a spectrum of different regulatory models, any and all of which can be tailored to individual substances and individual people. So on the far right, we have the unlicensed premises. And that's usually, I believe, what most people think of when they think of legal regulation, right? A situation where you can walk into any establishment and access any drug. But in reality, very few people are advocating for a free market in the context of currently illicit drugs. Most people tend to look toward the center of this spectrum and leftwards. So on the far left here, we have the doctor prescriber model, which I'm sure people on this call are most familiar with. And this is the most stringent type of legal regulation one can have. And it's where most of Canada's currently regulated substances tend to fall. So we have this model in the context of people accessing otherwise illicit substances like hydromorphone or morphone via a prescription. Next, there's specialist pharmacists. So under this model, there would be no prescription, but a specially trained pharmacist would act as the gatekeeper to a substance, kind of like a behind-the-counter sale. Then we have licensed retailers. These are operations similar to a dispensary or a liquor store. So the substance is purchased on-site, and then it's used off-site. But there are still regulations in place. You have to be a certain age, etc. For the licensed premises, the substance is purchased and consumed on site. If you imagine a bar or a restaurant where you can have a drink, again, there's regulations. The restaurant can only serve liquor if it has a license, and the license will control the number of drinks a person can have, whether you can have food sales, and ordinary age requirements. And then the unlicensed premises, as I mentioned, is kind of the free market style. The really necessary thing to understand about these different models is that none of them on its own is sort of a straitjacket or a single way of being. So just because liquor stores in Canada look a particular way and only have one criteria of age, it doesn't mean that all licensed retailers need to operate this way. Person might have to complete an educational session. They might have to be trained in naloxone. They might be educated on the side effects or the potency of the substance. These can all be tailored. And the same goes for the doctor prescriber model. There's a lot of resistance to a prescriber model, I think, among people who use drugs, but that's partly because our province has, I'm saying our province as BC, but I think all the provinces have really narrowly interpreted this model. The doctor prescriber model can be made far more accessible and low barrier than it is, whether it's in terms of who can prescribe, where a person can pick up their prescription, whether a person can carry their prescription, what the criteria are for achieving a prescription guidelines. All of these things contribute to how accessible or not a substance is in the doctor prescriber model. But the model itself is not inherently the way that it looks currently. There are ways to think more creatively under these models to ensure that we not only are able to control quality, but most importantly, ensure that access is real for people and that we don't set up a similar system to prohibition antithetical to prohibition where a person is obviously going to rely on the illicit market because it's simply too high barrier to obtain a prescription. So I think I will leave it at that.
It has been very enlightening and lots of things to think about as we move forward with possibly looking at these different approaches in Alberta. Thank you very much for your time.
Thanks really so much for having me.
No, thank you very much. And thank you everybody for attending, and have a good night.